On this week's episode of the Crushing Debt Podcast, go ahead, pay off your car.
Welcome to the Crushing Debt Podcast with your host, Florida attorney Sean Yesner, where our goal is to help you get rid of the financial bullies in your life.
So welcome back to this week's episode of the Crushing Debt Podcast. My name is Sean Yesner, owner and founder of Yesner Law, and again, I have a few announcements at the beginning of this week's episode, and I actually have an apology for you listeners that tune in week after week. So before I get to any of that, I do again want to mention our friend, our sponsor, Sam Cohen of Attorneys First Insurance. You know, I was listening to last week's episode, and I realized I said on the episode that I get no financial compensation by getting referrals over to Sam, and while that's partially true, in other words, when Sam gets a referral from me and is able to write a policy of malpractice insurance for an attorney or title company, he doesn't give me any money or any kickback from writing that policy. What he does is he writes a check on an annual basis and has for the last couple of years and sponsors the show. So he helps offset the costs of producing this show. So while I don't get a specific, thank you for referring attorney Joe Smith, here's a check, that doesn't happen. But I do get his continued support and I do get his continued input. And again, he does give me some money to offset the production costs of the show. And so from that perspective, he is a sponsor of the show. And so what does Sam do? He writes errors and omissions insurance, or like I said, malpractice insurance, E&O coverage, professional liability coverage for attorneys and title companies all over the country. Now, he has a particular focus on Florida, here where we're both located, and also in Texas, but he can literally talk to you about or write insurance for attorneys and title companies anywhere throughout the country. So a great way to refer Sam would be if you know an attorney or title company starting a new business, a new law firm, or a new title company, you can have them contact Sam at attorneysfirst.com or www.attorneysfirst.com, and Sam can provide them with an apples-to-apples quote of what kind of coverage he can provide, what the limits are of that coverage, all the information that you'd be looking for in order to bind malpractice coverage. So that is Sam. A great way to support the Crushing Debt Podcast is to support Sam. And while I don't get any individual kickbacks, it's not, I don't even think it's legal for that to happen. But again, the show does get a benefit by Sam being its sponsor. And so we definitely appreciate our relationship with Sam Cohen and Attorneys First Insurance. The other thing I wanted to mention, last week's episode was we're back, meaning we're back in the office. My podcast recording equipment is in the office. Now, here's the funny thing. I said in last week's episode, what do you think of the sound quality? What do you think of the quality now that we're back? What I didn't realize is as I was recording, it was my webcam that was picking up the audio. It wasn't my microphone and my mixer, which I'm talking into right now. So those of you that listened to last week's episode and said, it sounds like Sean's in a barrel. What the heck is he talking about? The sound quality is terrible. It got worse from last week. Well, what do you think of this week's sound quality? What do you think of the sound quality now that I've got the mic and the mixer and all that stuff plugged in and working properly? Now that I'm telling the recording program where the input is coming from my voice. What do you think of the sound quality now? Is it better? Is it worse? Is it indifferent? I guess we'll figure it out as we go here. Because I also listened to the episode and said, what the heck was I thinking to even make that statement? But again, I guess it just goes to show you that it doesn't matter how accomplished you are as a podcaster. It doesn't matter how many episodes you've done. It doesn't matter how many years you've been podcasting. We still have brain farts and we still screw up from time to time. So I apologize for the audio quality of last week's episode, but I think I've got all that corrected and you should hear better audio quality from here on out. The other thing I wanted to do was update you all on PodFest 2020. So again, if you want to go to podfestexpo.com, that'll give you all the information for PodFest 2020, which is going to be in Orlando at the end of May. If I recall, it is going to be May 26, which is a Thursday, and it's going to end on May 29, which is a Sunday. So it'll be Thursday, May 26 through Sunday, May 29. I do know now that I am speaking at PodFest. I'm definitely speaking at PodFest on Friday. Looks like I might even be speaking twice, once on a legal panel and then once about interviewing skills. So I'll be speaking at least once, possibly twice at PodFest on the Friday of PodFest, which is the 27th. Now, I've got an offer for all of you as listeners. Last week on the episode, I also said that PodFest was going to do the Pay It Forward program again and give podcasters a limit of tickets that we could then give out to our audience for free. And I am happy to say that PodFest has given me 5. I asked for 2, and they gave me 5. So if you are a listener and you want to go to PodFest, let me know. Email me, Sean@yesnerlaw.com. Now, I apologize. This doesn't apply to some people that I've already talked to about PodFest here in the Tampa Bay area. But if you are a listener of the show, email me, Sean@yesnerlaw.com. Actually, better yet, leave me a review. Let me know what you like about the show in either on Apple Podcast or Spotify or wherever you listen to the show. Leave me a review. Let me know that you left a review of the show. Whether, whatever, 3 stars, 4 stars, 5 stars, 1 star, 2 star, whatever. Leave me a review of the show. Depending on how many I get, I'll put all those names in a hat and I'll draw a couple of winners, and you all will have free tickets to PodFest. Now, you're going to have to pay for the hotel and you're going to have to pay to get there, but the admission to PodFest itself will be free. So thank you very much to Chris Kremitzos and the whole team there at PodFest. I've got some tickets to give away to some loyal listeners, so let me know. Reach out, let me know that you want to go to PodFest, and I will be happy to hang out with you at PodFest in Orlando for a few days here at the end of May. The other thing I wanted to talk about, so let's get to the actual content of the show here, Crushing Debt, and why I titled this episode, Pay Off Your Car. So one of the things when I deal with bankruptcy clients, and I had this happen to a potential client the other day, I was talking to this potential client about a Chapter 7 bankruptcy, and the client had a paid off, I think it was Ram truck. And it was an old truck, and it had a lot of mileage on it, been in a couple accidents, and so he said it was probably worth around $4,000. Well, here's the thing. In Florida, we have a $1,000 exemption for one car. So if you own one car or 2 cars or 5 cars or 10 cars, it doesn't matter. You get one $1,000 exemption to apply to one car. So in this person's example, he had a Ram truck worth about $4,000, he thought. Well, if we had filed bankruptcy, he only gets a $1,000 exemption. So what the trustee is going to say is, great, give me $3,000 or give me the car. Now, sometimes we can negotiate with the trustees. Sometimes, depending on who the trustee is and depending on the circumstances, we might be able to negotiate with the trustee to pay them some lesser amount, 90%, within 30 days or so, and that would free up the title to the car. Or sometimes we can spread those payments out over a very short period of time, 2 months, 3 months, sometimes. Now with cars, it gets a little bit more complicated because as soon as the bankruptcy is filed, the bankruptcy trustee owns everything. And so the bankruptcy trustee is responsible for that car. If the debtor gets into a car accident while the debtor is paying the trustee for the car, then technically the trustee could be sued for the debtor causing that car accident, potentially. Now, I don't know that that lawsuit would really go anywhere based on the laws, but I guess it could happen. That's what the trustees all tell me. So in this example, if you had a car worth $4,000 and you had to file bankruptcy, Chapter 7, liquidation bankruptcy, and there's only the $1,000 exemption, you'd have to pay the trustee $3,000 if you want to keep your car. Now, the first argument that I typically hear about something like that is, well, wait a minute, I need a car to get to work. I need a car to take my kids to and from school and daycare and this and that and the other. I get that. But Florida law only allows a $1,000 exemption. So I feel like it's part of my job up front to tell you, hey, this is going to be an issue in the bankruptcy. Here's how I suggest we deal with it. Now, how can we deal with it? There's a company out there that will provide funding after the bankruptcy is filed. So we get the trustee's permission, we get the court's permission, you borrow the money, and then you pay the trustee for the car. Now, the trustee then takes that money and spreads it out to your unsecured creditors. In this particular example that I brought up, the debtor had about $30,000 of debt. So $30,000 of debt, he would get $3,000. Creditors get paid off at 10%. That's how bankruptcy works. So one of the potential options is you finance the car again within the bankruptcy and use that money to pay the trustee and use that money to pay the creditors. That's one option. Another option, let's get a more accurate value of the car. I mean, if this person thought the car was worth $4,000, but we can pay $200 and get an appraisal that says it's worth $1,200, well, now when we take out the $1,000 exemption, you only got to pay the trustee $200. And typically, for just a few $100s, the trustee will let that go. It's not enough for them to administer an estate where all they're going to do is collect and pay out $200. It costs them more than $200 to do that. So there's a possibility there. One of the other things we could potentially do is file a Chapter 13 and then pay that $3,000 over time. If we did a 36-month plan, it'd be about $100 a month. 3,000 divided by 36, probably less, but around $100 a month. So that's another option. If the debtor, if the person filing bankruptcy, does not own their homestead, then we get a $5,000, what we call wild card exemption, that we could apply to anything. So we take the $1,000 car exemption, apply it to the $4,000 value in the car, and then we take $3,000 of the wild card exemption, and we apply that to the car, and now the debtor has about $2,000 left to cover the rest of their assets. Now, with this particular person that I was talking to, he owned his home, and so we only get a $1,000 wild card exemption instead of a $5,000 wild card exemption. So again, we could use the $1,000 car exemption against the $4,000 value of the car, and then the $1,000 wild card exemption. So now he would only have to pay the trustee $2,000, 4 minus 1 minus 1. He would only have to pay the trustee $2,000 and he could keep his car. The problem is, by using the $1,000 wild card on the car, we don't have that exemption available to protect furniture, clothes, jewelry, money in the bank, all the other stuff that he owns. So this could potentially be an issue for this particular debtor. I was talking to a potential client a couple of days ago, and they were very proud of themselves, deservedly so, proud of themselves for having paid off their car. The problem is they need to file bankruptcy and their car's worth 12 to 13 grand. And so we even have a worse scenario than the guy with $4,000, because now we've got to come up with tens of thousands of dollars for the bankruptcy trustee, or we got to refinance the car and pay it off again. So there's some issues there when you have cars and you're having to go through bankruptcy. And again, that's why I like to talk about this stuff up front so that we can address it. We can come up with a plan, and then that way when we file, we know exactly what we're going to do. Now, the reason I bring all this up, I've brought this up on previous episodes before, but the reason that I bring this up now, I saw apparently the legislature, both the Florida Senate and the Florida House, have approved a change to the law. Now, the statute that gives us the $1,000 car exemption is statute 222.25, and I believe subsection 1. That's the statute. For those of you that like to cite statutes, that's the statute that gives us all the $1,000 car exemption here in Florida. I recall seeing, but I can't find evidence that the legislature has sent to the governor's office a change that would be implemented, I think, July 1 of 2022, so just a couple of months from now, that would raise the car exemption to $5,000. That's huge. What that does is now this person that I talked to that owns a car that's worth $4,000, the entire car is protected if he were to file bankruptcy. Now his Chapter 7 gets much, much easier to file because he can keep his car. And as long as that car is not worth more than $5,000, he doesn't have to worry about the trustee requesting any money from him at all. So if the governor signs this bill, I will definitely let you know. I will definitely keep you posted. This could be huge for Florida borrowers. Now, what happens if you're outside the state of Florida? We got to look at what the exemptions are in your state. Or if you use the federal exemptions, I think the federal exemption for a car is in that $4,000 range. And that might be some of the driving force behind why Florida is looking at possibly raising its exemption limit up to $5,000, is because the federal exemption is already that high. Now in Florida, we have to take the Florida exemptions. We can't take the federal exemptions unless you're ineligible for the Florida exemptions. So it's rare that I get to take the federal exemptions, but when I do, the car exemption is higher for now than what it is in Florida. But stay tuned to the podcast. As soon as I hear more information, if the governor has or has not signed this bill and the language of the bill, and as soon as I know all of that stuff, I will definitely keep you posted. But if this law passes, if this, what I read is correct, and this law passes, this could be huge for residents in Florida that want to file bankruptcy. They would be able to, in most cases, protect their cars. Also, we've got the value of cars going up. So that could be another driving force behind why this bill was was proposed and why this bill passed is because cars are going up in value. A car that was worth only $2,000 or $3,000 may be worth $4,000 or $5,000 or $6,000 now just for its parts. A car that was worth $10,000 or $11,000 or $12,000 may be worth $15,000 or $16,000 or $17,000 now because of its use. So again, I will definitely keep you posted about anything that I hear about the increase in the value of the exemption for cars for Florida residents, assuming what I saw on Facebook is true, because, everything on the internet is true all the time. So definitely I will keep you all posted. The other thing I wanted to talk about before I go today is another bankruptcy issue, and it's something that I've had happen a few times here, and so I wanted to talk about it. Conversion and dismissal of bankruptcy cases. So typically in bankruptcy, Chapter 7 cases cannot be dismissed, especially in situations where there is equity. So if we had filed this case and the trustee was entitled to the $3,000 of car equity, chances are the bankruptcy trustee and the U.S. trustee would not allow a dismissal of the Chapter 7 case because that would take assets away that could be used to pay creditors. Now compare that to a Chapter 13, a payment plan bankruptcy case. Those can be dismissed by simple motion at the will of the debtor. The debtor or debtors can say, we don't want to be in bankruptcy anymore, and dismiss their case. And I think the logic behind that, too, is because Chapter 13 is a payment plan. It doesn't depend necessarily on the value of the assets. And if the debtors can't make their payments, why keep them stuck in a plan that's unaffordable based on their disposable income? Now, the only exception to that rule is if the case was converted from another case. So if you have a Chapter 7 case and you convert it to a Chapter 13, you cannot dismiss it without approval of the court. If you don't make your Chapter 13 payments, it gets reconverted back to a Chapter 7. So you want to be careful when you're talking about dismissing cases. Plus, you also want to be careful in terms of what's the impact of dismissing the case going to be. Are some creditors who didn't get paid in the bankruptcy going to be more aggressive in coming after you now because your case got dismissed? So the protection of the bankruptcy stay is now lifted. So you really want to be careful when you're talking about dismissing a case. But let's talk about conversions, because that's sort of the topic that brought all of this to bear. You have the ability to convert a Chapter 13 to a Chapter 7, a payment plan bankruptcy to a liquidation bankruptcy. You have the option of converting a Chapter 11 to a Chapter 7. The only thing you can't do is bounce between 11 and 13, unless potentially it's an individual 11, and that's because Chapter 13s are only for people, where Chapter 11s can be filed for businesses. So if it's a business that filed the Chapter 11, they can't convert to the Chapter 13. But I think I'm getting a little too deep in the weeds for you all here. But basically, you can convert from a 7 to a 13, from a 13 to a 7. The interesting thing about the conversion is that everything relates back. So if you file this case January 1 and you convert it June 1, the conversion relates back to January 1. So what was the value of your assets on January 1? That's going to factor into the conversion. Now, interestingly, from what I understand, the law here in Tampa, and obviously if you're not in Tampa, if you're not in the Middle District, you've got to check with a local bankruptcy attorney to make sure I'm being accurate in where you are. But I know that here locally, for now, our trustees, our Chapter 7 trustees will consider, so if you pay money to the Chapter 13 trustee and then you convert to a Chapter 7, any money you've paid to the Chapter 13 trustee is post-petition. And so it is not a part of the bankruptcy estate once the bankruptcy is converted to a Chapter 7. So I have clients right now that are in a 13. They want to convert to a 7, but I've already told them when you convert to the 7, you have value in your assets above the allowed exemptions. The Chapter 7 trustee is going to want some money, but you're going to get a check back from the Chapter 13 trustee, and that check from the Chapter 13 trustee is not going to be an asset of your bankruptcy estate. So we can use the money you get back from the Chapter 13 trustee to pay the Chapter 7 trustee the value of those assets that are above the allowed exemption. So that's how we can fund this. Now, we don't want to do this as a strategy because I think that's a bad faith filing. In other words, we don't want to file a Chapter 13, let it accumulate some money, and then pull the trigger and file a 7 and say, haha, now we've got all this money to pay you, trustee, without having filed the 7 originally. when this particular Chapter 13 case was filed, the borrowers clearly qualified only for a Chapter 13. What happened was one of the spouses lost her job and cannot find another one and has decided to stay home to raise the kids. Well, now, only on one income, they clearly qualify for a Chapter 7. So the conversion, the reason for the conversion is the substantial change in income, the substantial drop in income. And I think that's what's going to allow us to do this without the pushback from the trustee, the U.S. trustee, the Chapter 13 trustee. I think if we just filed it to allow the 13 to accumulate money as a savings account, that could be considered a bad faith filing, and that would be challenged by all the bankruptcy trustees. But it is still something we can do. I think we can convert these people from a 13 to a 7 and get them discharged. And I think that this strategy will work. But again, I will keep you updated. The other thing about a conversion, going the other way from 7 to 13, we can go from 7 to 13, for example, if somebody picks up a job, or if the U.S. trustee or bankruptcy trustee think that the debtor in this particular case has underreported their income. They may force a conversion to a Chapter 13 and go from a liquidation to a payment plan. Or if the trustee is pursuing that car that has 5 figures of equity in it, 10 grand of equity in it, well, at that point, you can convert from a Chapter 7 to a Chapter 13, and instead of paying the trustee a chunk of 10 grand to pay for the equity in the car, you can pay the trustee that 10 grand of equity over some longer period, 3, 4, 5 year period of time. And that might be a reason why you would want to convert from a 7 to a 13. But again, what I would suggest, if you have questions, give me a call. If you have an attorney currently, give your attorney a call. I'm not really excited about Monday morning quarterbacking other attorneys, but if you have questions, certainly contact my office. If you are not in Tampa, if you are not in Florida, then I would suggest you contact a local attorney that's more familiar with the local rules in your area. But I'm always happy to answer listener questions here if I can. So I think that'll do it for this week's episode, a little bit of a shorter episode. I've got some interviews here scheduled in the coming weeks, so you'll get some really cool interviews coming up. Now that I'm back in the office, I can bang out content a little bit more consistently for you here. So I think that'll do it for this week's episode of the Crushing Debt Podcast. Like I said, Podfest update, I do have some listener tickets available if you want to qualify for those listener tickets. I told you how to do it at the beginning of the episode. The update on my mic and my sound and my mixer, now that I've got the right inputs, hopefully the sound is a bit better than last week's episode. I'll keep you posted on what's going on with this increase in the car exemption here in Florida. And then if you have questions about converting or dismissing your bankruptcy case, absolutely let me know. But that'll do it for this week's episode of the Crushing Debt Podcast. I hope that at the end of the month you have more money rather than at the end of the money you have more month. And I will talk to you in next week's episode.
If you have questions that you think would make a great topic for a future episode, please email Sean or connect with us on social media. Sean Yesner and Yesner Law, PL, are Florida licensed attorneys. The information contained in this week's episode is not a substitute for legal advice. Your situation may differ, especially if you are located somewhere other than the state of Florida. If you have questions, please contact our office or contact a local attorney. Thank you for listening to this week's episode of the Crushing Debt Podcast.